I'll call the case of Jonathan Cash versus Pennsylvania Tube. We're here today on a termination and suspension petition. It's defendant's burden. Attorney Lafferty, do you have any exhibits?
Yes, Judge. I have first a narrative report authored by Dr. Black, 17 pages long, in which she indicates that even assuming that the claimant sustained the injury that was found in the decision on the claim petition, that he's fully recovered and there are no ongoing objective evidence of any problems in his low back or right leg.
And any other exhibits?
Yes, I also have a return to work letter sent by my client to Mr. Cash. And finally, I have a surveillance DVD taken by a private investigator documenting Mr. Cash.
Thank you. I'll mark these as exhibits. Any objections?
Hearsay objection to every exhibit, Your Honor.
We will admit these for supersedis purposes, and they will not be admitted for the case in chief until such time as depositions are taken.
Thank you, Your Honor.
Attorney Bailey, do you have any exhibits?
I do, Your Honor. I have a report from Dr. Wright, Mr. Cash's treating physician. It is his opinion, as his treating physician, that Mr. Cash is not fully recovered from his work injury, and he's still restricted in his capabilities as a result and is unable to return to his regular job.
Attorney Lafferty, any objections?
Hearsay, Your Honor.
This will also be admitted for supersedis purposes, but not for the case in chief until depositions are taken. Do we have testimony today?
Yes, Your Honor. I'd like to present the testimony of Mr. Cash.
Okay. Mr. Cash, raise your right hand. You understand that you need to tell the truth, the whole truth, and nothing but the truth.
I do.
You may proceed.
Can you state your full name again for the record?
Still Johnny Cash.
Okay, Johnny. Did you sustain a low back injury at work on October 15, 2010?
Confirmatory.
Mr. Cash, do you remember testifying the last hearing?
I sure do. I remember that.
Okay. And so it was in front of Judge Stigna as well, so we're not going to repeat that testimony. So I'm going to start where we left off the last time. Is that all right?
It's all right with me.
Okay. Since then, have you continued to treat for your injury?
I have. I've continued to treat with Dr. Wright.
And what type of treatment has Dr. Wright provided to you since you last testified?
Well, he's done some injections, spinal cord injections. They really haven't done too much of anything, unfortunately. Now he's talking about implanting some kind of stimulator, spinal cord stimulator of some sort.
Are you on any medication for your injury?
Just Percocet and Flexeril, that's it.
Johnny, are you okay?
I'm fine. I'll be all right.
And the judge indicated before, if you need to stand up, just let us know and you're free to do that, okay?
Like I've indicated before, I need to lay down.
You continue to suffer symptoms as a result of your injury?
Oh, yeah. Yeah, I do. The back pain's less than it was. I mean, my lower back's better. But my right leg, I still have constant pain going down that. It's pretty bad. And I don't know that I'll ever go away.
Has your doctor released you to your regular job?
No, Dr. Wright hasn't released me to return to work at my regular job. He has me on 25-pound lifting restrictions. I'm not allowed to repetitively bend, push, pull. Like I said, no lifting over 25 pounds.
Okay. Mr. Cash, do you believe you're fully recovered from your work injury?
No. I'm still a hot mess, I'll tell you that. I have this constant pain down my right leg. Anytime I try to lift something over, say, a gallon worth of milk, I lose my balance. I can't walk on uneven surfaces very well either. So no, I don't consider myself fully recovered.
If your doctor would release you to a specific job, would you at least try it?
Yeah, I'd love to go back to work.
Mr. Cash, those are all the questions I have for you. Mr. Lafferty is sure to ask you some, though.
Sure witness, Mr. Lafferty.
Mr. Cash, do you agree that you received a letter from my client in which they graciously offered to allow you to return to the job that you had prior to your alleged injury, even though you've refused to work for the last 2 years?
Oh, Judge, I got pardon me again a minute. It's acting up. I got to stretch it out again.
That's fine. Take your time.
That must be something with Attorney Lafferty. What was the question?
Did you get the letter that my client sent you indicating that they have taken the extraordinary step of holding your pre-injury job available for you?
Yeah, I got that letter.
But you didn't attempt to go back and take them up on that gracious offer, did you?
No.
You didn't even attempt to perform the job.
Well, no, I didn't, because that job is not within my restrictions. And from my time at Pennsylvania Tube, I couldn't be able to do that.
So have you been out looking for any other jobs that you feel are within your restrictions?
No. And I'd like you to tell me exactly how someone in my condition with my restrictions is supposed to find work in this economy. Do you really think it's worth my time to go out looking for jobs?
Well, you're not going to know if you don't try, that's for sure. Should I take it to that your answer is no, you have not been looking for other jobs?
No, you could take it that way.
So do you consider yourself retired now?
No. I don't consider myself retired.
All right, Mr. Cash, switching subjects here. You've also seen the video which was submitted as Employer's Exhibit 3, which documents you performing various activities, correct?
I saw that piece of work, yeah. Yeah, I saw it.
And in that video, I see that you've come into this hearing with a cane today, right?
Yeah, nowadays I have to walk the line.
But in that video, you don't have a cane anywhere in sight, do you?
It's because I wasn't walking.
Also in that video, you were picking up a rather large planter, were you not?
I was picking up a planter. It may have been large, but it wasn't heavy.
What was it filled with?
I don't know what it was filled with. It just wasn't heavy. And moreover, as I said earlier, I don't have trouble picking things up. The low back pain's better. It's picking things up and carrying them that I have trouble with. And I didn't carry it, I just picked it up.
All right, Mr. Cash, those are all the questions I have for now.
At this point in time, it seems like it would be best to proceed to mediation rather than taking depositions. If the mediation is not successful, then we'll proceed to depositions. Both parties are agreeable with that?
Yes, Your Honor.
That's fine.
At this point, we'll also rule on supersedis. Supersedis is going to be denied at this point in time, and that can always be readdressed later if necessary. So we'll proceed to the mediation then.
Thank you.
Thank you.
Thank you, Judge.